I'd like to say thank you to our platinum sponsor, Workers' Compensation Lawyers Association platinum sponsor, Preferred Capital Funding, who's in the back of the room to talk with you about what they do and to hand out little goodies if you would like them. So please see our platinum sponsor if you get a chance. So I'd like to go ahead and begin the program. As you know, we've been doing this Lincoln Birthday Professional Responsibility Boot Camp now for the last decade or more. And in the last few years, we've actually been complying with the new MCLE rules regarding professional responsibility for the 2 hours of special professional responsibility program that you're supposed to be taking, which include issues involving diversity and inclusion and issues involving mental health and substance abuse. So this year we are going to have 2 one-hour programs about that, but to lead us off on the general kind of professional responsibility and professional ethics topic is Mary Andreoni, and as you all know, Mary Andreoni is with the Illinois ARDC, and Mary has been so gracious to WCLA. She's been doing this, I think, for that last decade or so that we've been doing the program. She always shows up, and she's always very interesting and telling us about new things that we need to know about. So, Mary Andreoni, thank you.
Thanks, Dave. Thanks for having me back. I always like this group. You know, you guys are like down to earth. You're real. So what I'm going to talk about in the hour I have, I'm going to give you just a quick, and everything's going to be quick, broad brush, but just an overview of the legal profession and how it's being regulated in Illinois, what's going on in Illinois. And then what in my own opinion, are some of perhaps the top legal ethics trends for 2019. In other words, what I see is what people are talking about a little bit more. One thing is uniformity of the ethics rules. I'm going to talk about that. Malpractice and succession planning, law firm cybersecurity, sexual harassment in the profession, lawyer health and wellness, civility, and then just to end it off. As you know, I mean, the ARDC, you know, is only one segment of where a lawyer's conduct can be reviewed. You know, it's the regulatory. We only affect the lawyer's ability to practice law. And when I say only, that's way understatement. That's our professional, you know, livelihood. That's our reputation. That's pretty much our identity as lawyers. But we affect the lawyer's ability to practice law. We don't put lawyers in jail, as much as the public would like us to do that. That's up, if there's a crime committed, that's up to the prosecuting authority. Certainly, any lawyer appearing before a tribunal is subject to the regulation as far as the conduct of the proceedings before that judge. So a lawyer could be held in contempt. And then there's also the civil aspect. If a lawyer neglects a client's case and fails in their duty of competence, and there's a breach of that duty, there could be malpractice consequences. But we only look at it as a lawyer's license. So just very briefly, here's our investigative process. As you see, any of you that have gone through that rather cathartic experience, it's confidential. When we receive something, we always ask that it be in writing. We're not going to email complaints just yet. There's always a big discussion in the office and a debate about whether or not we would allow people to email us their grievance about a lawyer. We always feel as though not to thwart people in their ability to send us information, but just that there should be more deliberation. And I always, you know, most of us would agree that sending an email in the heat of the moment is much easier than writing it out. But everything that we receive is docketed and reviewed, everything. So it doesn't necessarily mean that because it's docketed, it has merit. It's just docketed and reviewed. And we formally call it a request for an investigation. It really is not necessarily an investigation. It's basically somebody giving us information and saying, hey, ARDC, I'm concerned about this conduct. Look at it. So we'll look at the information, but you'll always know if you're the subject of an of this, request for an investigation. So that's not secretive, and you'll know about it by receiving a letter from our office, and it won't be registration time, so it won't say registration materials, and you'll probably get a copy of it, and we'll ask you for a response. Again, it doesn't necessarily mean that there's merit to what this person is saying about you, but that we need information in order to figure out what has or hasn't gone on. If we don't need information from you, you'll get a letter from us where we have decided we don't need information and we've closed the investigation. So you'll know in that one letter that we opened it, we looked at it, and we closed it. We keep those records for 3 years. 3 years after the closure, all of that information is expunged. But that information, going back to that first thing, confidential, nobody knows about it but you, the person complaining about you, and the ARDC. You'll never see that on our website. Excuse me. You'll never see that on our website. Why? Because we're just looking at information that people have brought to our attention. That's only fair. Sometimes I hear from the public and maybe other lawyers who say, hey, that lawyer's, a menace. They treat their clients like crap, or whatever. Why can't I see that, 10 people have, filed something against that lawyer? Well, because we docket everything and we review everything. It's not given some sort of minimum threshold of merit in order for us to review it. So it's a way for the free flow of information. But when you're the subject of it, I know it seems as though this is extremely unfair. You feel as though you are under the microscope. You feel like the burden of proof is on you. None of that is true. Again, it's just somebody has sent something to us, we docket everything, and we review it. So try to keep that in mind. Immunity for persons communicating with the ARDC. Some people don't realize that this is in the Supreme Court rules, and when we get, when you talk about PIML for lawyers that are reporting other lawyers, sometimes you have a concern. You have some information, maybe you don't know the whole picture, and you're not required to investigate something in order to bring it to our attention, but you have something that is very troubling about another lawyer's conduct. You can send that to us and say, this is all I know. And maybe it's a Himmel duty, it's something where it's serious misconduct and you feel like, well, I know a little bit and it's really serious. It could be criminal. If it turns out, when we do our, we look at more facts and more information and it turns out it's not that, do you have to be concerned that that other lawyer is going to sue you in some sort of civil action? Well, if they do, Supreme Court Rule 775 gives you immunity from all civil prosecution. So if somebody, you might get a hothead lawyer and you presented something to us and they're say, I'm going to sue you now, as long as you confine your communications to the ARDC, you are good. And this applies to anybody that gives us information. Excuse me. This investigation, we had a 3.7% drop. This is from the 2017 annual report. 2018 will be coming out. It's filed with the court at the end of April. I'm doing the stats for 2018. We saw another additional I think it's like 3.2% drop. This has been a trend that's we've noticed since 2012. For some reason, 2012 went up to over 6,000. So we have seen a sharp, steady decline in the number of investigations that we docket. And for lawyers, you're like, this is great. People are complaining less. People must be happier. We hope that that's the case. We hope that. We don't know specifically why the reason is, why there is this steady decline. There is one reason, perhaps, that I think is attributing that, causes that decline, and that's perhaps that people are using lawyers less. This is one trend you're going to see probably across the nation. I was reading somewhere, I think it was in Forbes or something, they were identifying the top 25 occupations that are dying for the future. And, you think bank teller, postal carrier, farmer, I guess. But one of them was lawyers. That was very interesting, lawyers and primary care physicians. I thought that was interesting too. But why? Because the impact of technology, people are able to access, certain limited or free, self-help legal services on the internet. That's a trend, that's an impact that we're going to see way into the future. And we, I think, are seeing that impacting the number of people that are complaining to our office. Why? Because I think people are using words less for these more simple things. Because most of the people that complain to our office are more pedestrian clients, I guess, if you will. They're not corporate clients. They are, the bread and butter, real estate, probate wills, divorce, those kind of things. Even in divorce court, I've heard from judges where they say that they are seeing a huge increase in the number of pro se self-represented litigants in different courts. Workers' comp, you know this better than I would doubt that this would impact you necessarily right now. This is not an area where I think you can do it on your own. But that's something to think about in the future. Number of lawyers sanctioned last year, 118, and because our caseload is dropping so much, last year there were only 78. And, that's great. But you see that even so, it's still a very small number when you figure we have a lawyer population of approaching 100,000. We've got, I think, 96, 97,000 registered lawyers, so it's such a small percentage. But you see that the very top one, that's usually the area, disbarment or suspension until further order, which is sort of like a disbarment because that means that the lawyer has to petition at the end of the suspension period in order to get permission to get reinstated to the bar. So serious misconduct, the few lawyers that engage in this, and most of it is going to be money. It's always money is the root of all evil. It's stealing from clients, stealing from estates, stealing from settlements. That has never changed. What causes? Well, obviously, there's always the top clients and third-party harm. A pattern of misconduct. I always give that common example of, you've misdiaried a date and something has been dismissed, and maybe it's even time barred. This is terrible, but it's an isolated incident. It doesn't necessarily mean that the lawyer is incompetent or unscrupulous. We all make mistakes. It's going to happen, but it's isolated, and it's not something that's going to be repeated. But how you react to that mistake makes the difference between a perhaps civil malpractice case and a disciplinary one. So if you have an isolated incident where you've missed a date and something maybe is time barred, rather than tell the client honestly, this is what has occurred. These are our options. Maybe there's no options other than you need to contact another lawyer in order for us to discuss settling this, meaning settling it with my malpractice carrier if you have one, because at that point you have a conflict of interest. But if you're honest with that and deal with that in an honest way with the client, it's not a disciplinary. But if you decide to lie to the client about the status, and even perhaps go so far as to pay out your own money and pretend that it's coming from an insurance company, which we have seen, because again, some lawyer, this is our reputation, this is everything, our identity, and some lawyers, when they make a mistake like that, they're so terrified that they will go so far in phoning up a settlement, use their own money, and try to settle it that way and say, well, this is what came from the insurance company, we settled it. Those are really heartbreaking cases, because those will end up in some sort of discipline. Maybe not, disbarment or anything like that, but still, even a small suspension or even a reprimand, it's always on a lawyer's record. Record meaning, if you go to our website and look up a lawyer, it will show below their name, sort of a little bit lower on the screen, if they have been formally sanctioned by the court or if we're prosecuting them. So it can be very hard. But usually, It's these more serial neglectors. They've essentially almost like abandoned practice of law in their clients. Dishonesty and fraud, and again, lying is the easiest way to turn something into a disciplinary action. Lack of remorse never helps, and not cooperating with the ARDC investigation. Okay, so let's talk about trends, just very briefly. Uniformity of ethics rules. You know, we are getting, I mean, this is nothing new. Like I said, this is all going to be broad brush, but you're going to hear more and more about it. And the court just amended the rules, the admissions rules, to now Illinois has joined now 33. This article says 29. There's actually more. 33 jurisdictions that now accept the uniform bar exam. Illinois, they're going to start it in July of this year. And you think, well, what's that to me? I've been a lawyer for 34 years. I'm not going to take the bar exam. Well, if you want to go to another state, and you might have to take the bar exam, or you know something like that, where you're moving around more and you're taking the bar exam, and you want to maybe transfer to another state or score, it makes it easier for lawyers to perhaps get a license in another jurisdiction or move to another jurisdiction. Malpractice and succession planning. I think a lot of you we'll talk about this in a minute. But you see, now since 2017 registration year, now when you register, you're asked a whole bunch more questions. Up until 2017, we knew nothing about the legal profession other than male, female, the date you were admitted, and your age range, you know, your date of birth. That's pretty much all we had. Now we've got all this demographic information, which makes it easier for us, the ARDC, to present more things that are helpful to the bar because we know what our legal population really consists of. And now we can see practice setting, very interesting. Still, private practice accounts for over 68% of the profession, government and then academia. But when you break down private practice, you can see that sole practitioners are only 27.9%, and I think next year I think it's over 28%, just a little bit bumped up. So that's still a significant part of the profession, and when you add into that smaller firms of 2 to 10 lawyers, the majority of the private practice bar is not the mega firms. We are still holding strong with small and sole practitioners. And that number has not decreased, at least compared to last year, because that's all we've got to start with. But when you look at the malpractice responses for each of those practice settings, again, private practice, not government lawyers, not in-house corporate lawyers, but lawyers that are representing clients, with an S, private clients. You see the malpractice responses, and for a sole practitioner, 41.5% have said that they do not have malpractice insurance, even though they are saying that they're representing clients. And you see the difference when you get to firms of at least 2 lawyers. Only 9.1% say no. So I guess when you get a partner, you want to make sure, hey, you know, we're covered. But you know, when I'm me, I guess I'll be on my own. So this was kind of a troubling statistic, and we did ask for reasons. You could pick as many reasons as you wanted, but interestingly enough, the majority, 47%, wasn't cost. It was the nature of my practice involves minimal risk. I thought that was kind of an interesting response. And assets insufficient, you know, never considered it, it was only 3%. But when you look at least for solos, because again, 41.5% said they didn't have it. I looked at the practice area, oddly enough, real estate, criminal, limited engagements perhaps, short-term client relationships, you know, one-offs, if you will, not continuing perhaps relationships, or if they are, they're many years apart. Oddly enough, estate planning was in that. So you're going to hear more about, you know, this malpractice, you know, across the nation, a lot of jurisdictions are looking at requiring, only Oregon, I was just in Portland I just flew in yesterday, Oregon is the only state that requires legal malpractice insurance.
but there are several other states that require very specific disclosure of a lawyer to their clients about the fact that they do not have malpractice insurance, and in some regards, if they don't have a certain level of insurance. Illinois, what do we have? We have, in your registration, you have to answer that yes or no question. Do I have it? Yes or no? Okay. And what's the dates of your coverage? That's all. We don't know where your coverage is. We don't know what the amount of your coverage is. Now, if you're practicing as a legal entity in Illinois, you know, like a limited liability company, you have to have a certain level of malpractice insurance. But otherwise, we have no idea what you have. And interestingly enough, the Illinois House of Representatives, I didn't, really pay too much attention to this until I heard about it in the office. They passed a resolution where they wanted to direct the ARDC to, or urge the ARDC to further amend Supreme Court Rule 756, it's a registration rule, to require Illinois lawyers to disclose to prospective and current clients if their insurance has lapsed. So, a lawyer would say yes, when they register for 2019, it could lapse, 2 months after they've said yes, and they haven't changed their updated their registration information. So this is kind of another attempt, and they wanted resolution, copies of the ARDC. I'm not privy to whether or not this is going anywhere. I don't think so, but let's put it this way. It's always up to the Supreme Court. It's not the ARDC. It's up to the court. We can advise the court. We can give information to the court. We can gather statistics for the court, but it's always up to the court to study this. And this thing, as far as I know, has no traction right now. But this is a trend that you are seeing talked about across the nation about lawyers not having malpractice or not disclosing that fact to their clients. So you're going to probably hear more about it. One thing we did do in Illinois that a lot of states in the country were calling us, they found it very innovative. The court did amend the registration rules, though, to say if you are in private practice and you are representing clients and you do not have malpractice insurance, you have to take this 4-hour self-assessment course, otherwise known by this god-awful acronym, PMBR, which actually stands for Proactive Management-Based Regulation. Sounds awful. But we had about 7,000 lawyers that were registering for 2019 that were required to take it. I don't know if any of you in this audience took it. Any lawyer could take it. You didn't have to be in that group. But if you were in that group, you couldn't register for 2019. Has anyone taken it that wants to admit it? Does anyone, let's put it this way, did anyone hear from another lawyer saying what they thought about it? Yes?
It's very negative. It's just very time consuming. In fact, this was someone who's a lawyer who doesn't actually practice and felt that having to take it was no good.
Yeah, so you heard that, and that is what this gentleman heard from others, it was negative, it was time consuming, and that this one particular lawyer said he just doesn't practice. That was part of the problem. Believe me, I took so many calls from so many lawyers that were having so much trouble taking it. And one thing, there's a great group of lawyers that are well into their 70s and even 90, and they are still practicing, which is great. You can still, able to do that. But a lot of lawyers, some of them, particularly the older lawyers, and I'll just tell you this because I think registration should have made this clearer. If you have an active status license, you are asked the question, do you currently practice law? That's yes or no. And you think, oh, that's an odd question. I have an active status license. You can answer no and still have an active status license because what that question is asking you is, are you representing clients? Because there's an awful lot of older lawyers who just want that card in the mail. So I had to explain to them to change it to no. So if you're not representing clients, so you can tell those lawyers, if you're not representing clients, and you just want that active status card coming in the mail, you can do that. But if you are representing private clients, even one, Even one. And I did talk to several lawyers that were, well older, but if you're doing that, you still have to take it. But it was very time consuming. I thought so too. It didn't take 4 hours. But we're going to try. We're going to try better. But that's something, any of you can take it, any part of it. There's 8 parts of it. Succession planning, that's the other theme, particularly in Illinois, that you're going to hear more about. That's a question we ask you in registration. You think, so many lawyers. If you can see, let's just look at sole practitioners, because this is really where the rubber hits the road for a succession plan. Of the 13,000 sole practitioners, only 17% said they had a succession plan. Over 76% said no, and 6.1 said they're not sure what that is. And oddly enough, as you get farther down into the firm range, like lawyers, 26 to 100 lawyers, almost 49% said they didn't know what we were talking about. So what we're talking about with succession planning is basically contingency planning. It is not a succession of the continuation of the business to be passed down to the next generation. That's not what we're talking about. That's certainly part of it, to that extent, but what we're really talking about is contingency planning. What's going to happen to your clients if something happens to you? That's basically what it is. And if you're a sole practitioner, you can see that this is really a dangerous area, because if you're the only one, you have no staff, you have no associates, you have no secretary, only you know the password to, what to get into your computer, only you know where, the client trust account is really being maintained, if you're the only one that's the signatory or the only one that has the ability to do something. What about what's going on in court? You have to think about those things. Easily when I came this morning, I slipped and fell on the ice. What if it was worse and I fell and hit my head and I'm in a coma? Then what's going to happen to my clients if I can't get into the office, if I can't attend the business? So that was the whole thing about succession planning. And the top areas, again, real estate. But estate planning, now that is mind-boggling. It's like physician heal thyself, right? It's like you never take care of yourself. So apparently some of these lawyers have not taken the time to really figure out, if I'm sick, maybe my spouse is sick, maybe your child, you have to fly out, halfway across the country to attend to a sick child. So you have to have those mechanisms in place so that you can cover things, have things covered. So you have to think about that plan. But there is a proposal that was put together by the ISBA. Some of you may have been involved in it, where the ISBA, their committee and their governors, recommended adopting a new Supreme Court rule that would require lawyers all active lawyers engaged in private practice of law to designate someone. This is a requirement, or at least show that they have something in place in their estate planning. So in other words, there is a point person. And then there's other requirements. It's a very, very lengthy rule. I've only glanced at it. It's very long, but it's something where that is something that the State Bar has really jumped on, the succession planning. And it's going to be something we're going to be talking more about. Will the court adopt this? I don't know what stage it's at, but right now it's just something that's been presented to the Supreme Court by the ISBA. And I think it's going to get a lot of discussion. But if any of you are interested, you should look at the proposal. It may be something that looks like a hugely onerous rule, but on the other hand, I think you can take from there certain things that you can start thinking about and perhaps doing, like having some sort of list of where is the client's calendar, where are the bank accounts, where is the password, somewhere where you can put that together So that, you know, you have a book or something, and somebody that you know and trust, maybe your spouse, off-site, you have it off-site, they can go to the book and they know this is how we can access things. So you can look at it and look for it and say, maybe there's something I can start doing. The ARDC does have a couple of webcasts on our website, and they're all, you know, CLE accredited, so you can always look to that. But in terms of what is required presently under the rules, you see there's a comment. That's not part of the rule, but the comments flesh out the meaning of the rule. So diligence, you know, in other words, preventing, you know, avoiding neglect. You know, it does say that, you know, lawyers, particularly sole practitioners, need to prepare a plan that has, at a minimum, designates another competent lawyer to what? Review client files, just to find out, you know, what's up in court, so they can make sure that everything's preserved, the status quo. Notify clients of either your death or disability, and determine the need for protective action. Like, you know, we got to go and we have to call the other side and let them know that yes, you know, there's something that needs to be done. Even the trust account rule. This is part of the record-keeping rule, and it says, for the trust account, you have to make appropriate arrangements for the maintenance of records, not, you know, for the closing or even the sale or merger of your office. You want to have good trust account rules. We do, the ARDC in certain instances are appointed as a receiver for certain lawyers that have abandoned the practice of law or suddenly died, and there is nobody else that will step forward to try to organize what's going on. Maybe it's, you know, they just have a spouse and it's just too overwhelming. So we'll be appointed a receiver, and the trust account has been very challenging for some of these lawyers who are, you know, gone, to try to figure out their records. You have to have good records, not just because, hey, maybe somebody needs to look at them in case I'm not there, but if you want to sell your practice, you know, we can sell our practice now. If you want to sell your practice, an organized office is great records, organized, clear, makes it much easier to sell your practice. Nobody is going to buy your practice if they know your trust account records are a mess and they can't figure it out, because they do not want to be stepping into that liability. Law firm cybersecurity, I'm not going to spend too much time on it because who can keep up with it, but, you know, there was you know, you have to be careful about, particularly if you've got other, like, staff even, you know, paralegal or some other assistant in your office. You want to make sure that they're not downloading unknowingly things, malware that would get into your system. That's what happened to this lawyer here. A hacker got into her system, was able to access her bank accounts, and they looted the trust account. That is a nightmare. That is one hell of a nightmare. So always be careful. Make sure if you do have staff that you have protocol so that you know that they are not accidentally, or even you, accidentally downloading things. How about, you know, the emails we all get, your lawyer, your counselor, you know, I'm in, you know, halfway across the world, and, you know, I want to, you know, hire you to collect this money. You know, we all get that. We're getting to the point now we know how to ignore that, but some lawyers, including those some in Illinois, have been brought in, you know, to that. And let's face it, those were the beginning, you know, amateurs. They've gotten much more sophisticated. They throw in names of companies you know of, maybe even other lawyers you know that you know of. Maybe they'll even have somebody come to your office, you know, the purported debtor, you know, or something. So. But if you feel as, you know, anything that's too easy, because these are easy cases, right? They're always collecting a debt, and suddenly the money is paid by the purported debtor so easily that you've either made one phone call or you haven't made any phone call. It's like they're suddenly showing up and your supposed client, who's halfway across the world, wants you to wire it. Everything's got to go fast. So these things are not usually drawn out. And there's something where you know, hey, how many times has this ever happened? You know, I've collected on a debt for a client and I did virtually nothing. It just rained money. isn't that great? So, always be careful with this. You're not violating your duty under the trust account rule. You have a duty under the trust account rule to, notify your client, hey, we've received funds, but also prompt delivery. But prompt means common sense. What's reasonable? And you are not violating that duty if some client you've never met, have a very limited relationship, suddenly wants you to wire it fast. Hey, oh, you got the check? Okay, wire it, next week, because, if I don't get it, our business will go under. If that doesn't make sense, and it's just something where you're, again, you've never met this client, and, you can wait, because depositing that check into your trust account does not mean it's been collected, right? It's just available to withdraw. And you would not find out that that's a phony check that you had deposited until it's gone through the check clearing process, and that could take probably 2 weeks. So you'll find out after you've wire transferred funds that what you deposited, if there was money in the trust account, it has gone to this thief, and the money that went was money that you were holding for other clients. And you'll be responsible for that. So it can be very tricky. So always, when something tells you something's not right, stop and pause, because that's the whole root of these scams, is to get you to act before you can think. This was just an interesting case from actually a couple years back, Johnson & Bell, but it was kind of an aggressive, case where, and it went nowhere. This was in the federal court, where they were trying to sue on behalf of a client of Johnson & Bell, as well as other clients of Johnson & Bell. They were trying to make a class action where they determined, even though there wasn't a breach, that their billing system and therefore their computer security system was arcane and subject to, it could be very easily attacked. So they brought this class action against the firm for lax security measures. It didn't go anywhere, but it made a lot of national news. Even scams targeting lawyers with fake ARDC complaints. That was a couple years ago. I heard about it from some Illinois lawyers, but it was really all across the country. It was, it was kind of another take on the IRS scheme. It was like, in our case, it's like somebody complained about you or something, but send us money. It'd be nice, but no. It just didn't make sense. None of this stuff. That's why in any of these cases, you should always verify what you're doing. I'm not going to spend a lot of time on this. And we have some email lists on that. Technology. The rules were amended. The comment to the competency rule, you should know about, the benefits and risks of using technology. A lot of states have that. In the client confidentiality rule, though, that was part of the rule where it says the lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure or access to information relating to representation. So it's not a comment. This is part of the rule. Anything that's a violation of rules could subject you to discipline. So to the extent that you are not taking making reasonable efforts to protect confidential client information, that could be a breach of 1.6 and possibly something that could lead to discipline. We don't have anything specifically yet, but I'm sure we're going to have it soon. So reasonable steps, I've just given you, understanding the threat and looking at how you're communicating with your clients, and is this the best protected way to do it? There's an ABA, and then sexual harassment. Obviously, there's been a lot of discussion. This was an older case from the ARDC from a few years ago, but this is something that has always been and never gone away. So it's gotten more discussion, but this was a lawyer who posted a job description for a legal secretary on Craigslist. And he had quite a bit of interesting information in there. He wanted, in particular, the interested applicants to send a few pictures with a description of your physical features, including measurements. And one woman responded to that, and the lawyer defined what additional duties would be required, which was basically having sex with him and his partner. And that lawyer was suspended for 1 year UFO. I know that sounds very, very harsh, but there was other aspects. He lied to the agency about the ad. It's never a good thing. As well as neglecting two cases. And finally, he did not appear for his disciplinary hearing, which is always institutional. So you see that, so if you ever want to read it. But sexual harassment comes in many forms. This is a very recent case. A lawyer working at a firm, which I guess had a very casual, they had some dress policy where you could come to work casually, but if if there were clients there or you were meeting with clients, you had obviously change into a suit. So a lot of the lawyers had like change of clothing in their offices. And this one attorney placed a hidden video flash drive in his coworker's office and basically recorded images of him changing. And he had that. So he got a 2-year suspension UFO. So this was a male lawyer who was the subject of being filmed by another lawyer. And in this case, I'm not going to spend too much time on it, it happens across the country. This got a lot of news. It was in Iowa. This was a county prosecutor, and he took his wife and 2 daughters on vacation to somewhere in Minnetonka. And he was basically pestering for hours the young desk clerk, basically, soliciting her, saying all these inappropriate things. And he even gave her his business card, and she kept thinking, what lawyer talks like this? So she complained to her supervisor, and ultimately this was brought to the attention of the Iowa Supreme Court, and there was something brought to them, but the Iowa Supreme Court determined that sexual harassment, at least in this case, was not sufficient enough to remove him from office. So that was a resolution in that case. But in terms of present-day rules, what we have a prohibition. This was enacted, added to the rules, probably about within the last 5 years. I can't remember exactly when. A lawyer shall not have sexual relations with a client unless a consensual sexual relationship existed before the attorney-client relationship commenced. I know we're prosecuting one case now, very young lawyer, only admitted a year, and he was going to represent this woman in her divorce case. And he immediately, she says, this is very expensive. Maybe I gotta rethink this or go to another lawyer. And he said, well, we can work something out where if you perform certain sex acts, I can reduce my fee, or maybe you can write all off. I mean, immediately, to somebody, a woman who's gone to him, she's a stranger, a young lawyer, young. So it's not, creepy older lawyer. It's somebody who's, So we're prosecuting that. I was, and it's somebody only a year admitted. Predators, criminal behavior, those are character things, sometimes it knows no age. Committing a criminal act reflects adversely on a lawyer's conscience. So solicitation even for a sexual act can get a lawyer into criminal. Right? And I think that's how we heard about it. She went to the police with that information. She was so aghast. As well as presently in Illinois, we have a rule where you cannot, if you violate a federal, state, or local ordinance or statute that discriminates on the basis of race, sex, religion, etc., if that act was committed during your employment, and if it was adjudicated that you violated a statute or ordinance, then you could be subject to discipline. And I know that there's an ABA model rule that's out there that I talk about. I'm not going to talk about it, but this was put out there. It basically is a different take on this rule, so I'm not going to talk about it. I'll leave that for dinner. A lawyer's mental health and wellness. We have in the CLE rules, as diversity and inclusion. Now we've got that hour, requirement. It's great. Interacting with people that are different from trying to treat everybody with respect, but how about treating yourself with some respect? Mental health issues in the legal profession is a very troubling issue. Lawyers, I don't need to tell you, it's a stressful profession. And the lawyers that are disciplined every year, we can only, of the ones that are disciplined, that actually participate in their disciplinary proceedings, meaning they show up, I can identify probably 25% of them have some sort of, issue, it's substance abuse or some sort of, mental health wellness issue. Usually it's depression, anxiety, things like that. But we don't know about the ones that don't show up. A trend at our office that we've noticed is an increasingly number of lawyers are defaulting. They are just giving up the ghost. And, we can suspect that some of this is probably, driven by issues like that. Look at that. This is a very sad case. Young woman lawyer, she ran with the wrong crowd when she was young, was facing a felony conviction and drug possession and sale, and out in Will County, they had something where it's like a second chance, and she went through the drug court program, so she was able to not have that conviction on her record, so she could pursue her lifelong dream of being a lawyer. And she ultimately did become a lawyer, got admitted, and where was she hired? The Will County State Attorney's Office. But unfortunately, she fell back into drugs with the wrong people, had a number of arrests, not just in Will County, but also in Grundy County, where she was a candidate for Grundy County State's Attorney. So, and she's only 34 years old. So very, very difficult case. You can see how the pernicious way that drugs, in particular, will get a hold of someone. So this is something where we do see, unfortunately, a lot on that laptop now. As you can see, we do have those requirements now as part of our CLE training. And Matt will talk about this, but I want to emphasize this too, is that to the extent that a lawyer needs to get some sort of help or needs to reach out to another lawyer, to the lawyer's assistance program to get that lawyer help, you are allowed to disclose whatever is necessary in order to get that kind of help, to reach out either for yourself or to the lawyer's assistance program or another type of lawyer's assistance program in order to get that lawyer help. And we have at the ARDC, as you remember I said, our investigations are confidential. We were never allowed to disclose them outside the ARDC unless the Supreme Court, at least one Supreme Court justice, permitted us to do so. But this was added in 2006 to allow the ARDC, where we had reason to believe that a lawyer needed help, that we could refer that information to the lawyer's assistance program. That was a huge thing, and we've been doing that more and more. Monitoring, we monitor currently over 100 lawyers, most of it for substance abuse and mental health concerns, as well as to a certain extent law office management and restitution. Restitution can also be part of a lawyer's disciplinary order, but it is not a judgment, not a monetary judgment. So if a lawyer doesn't want to get their license back, there's no way to enforce it. But we do that, and we're doing that more and more with probationary. Civility, this kind of goes hand in hand with some of these mental stressors, these difficult things, because I think that's why people act out in an uncivil way. The Commission on Professionalism, it's a separate agency. Of course, they did a survey in 2014. Granted, I don't think they asked a lot of people. I think it was maybe 4,000 to 5,000 lawyers. But they, interestingly enough, they asked, would you describe your colleagues as very professional or civil? And 91% of them described their colleagues as either civil or very civil. So most lawyers are like, you know, most of the lawyers I deal with, they're very professional. But if you've asked, you know, you've asked, did you ever experience any uncivil or unprofessional conduct in the last month? 85% said yes. There's always a few bad apples. It's like, you know, the disciplinary side, you know, 98,000 lawyers. There's usually only 100, you know, that are really, and of those 100, really, there's only like 50 that are the really bad ones. There's always those few that make life difficult. And they identified in that survey 3 types of unprofessional conduct: prejudicial, saying inappropriate comments, you know, basically attacking words, race, age, or gender. We have plenty of cases like that where lawyers have said things like that. Rudeness, you know. Strategic instability, misrepresentation, or stretching the facts, playing hardball, or indiscriminate, frivolous use of pleadings or motions. That was number 1. That was number 1. I think most of us can brush off an occasional rude comment, you know. It's like, hey, that lawyer's a jerk, but you know, I can live to tell another day. But strategic incivility, I know that can make your case and life hell. And most of that will occur in telephone conversations, interestingly enough. Secondarily, in email, texting, or written correspondence. What do you see way at the bottom? Videotape depositions. Anytime somebody's, you know, conduct is seeing the light of day, in court, before a judge or tribunal, in a videotape deposition, something where they're being recorded and they know about it, those are where you see less bad behavior. So what were some of the suggestions? Imposing or enforcing consequences through the court system. Well, the court always has, you know, their authority to regulate conduct for them. Training on civility and professionalism, that is part of that 1 hour of CLE and mental health. Civility training is part of it. Educating judges better to deal with incivility. I know a lot of us, I was a litigator before I came here to see. I know that's always something where you always feel like, I wish this judge would do something. But, you know, they're not regulating children's conduct. They're trying to get these cases done efficiently and fairly. So to the extent that that interferes with that, that's when you bring it to the judge. But otherwise, I think you have to kind of, but these are the rules. If we did prosecute a lawyer, these are the rules that we look at. You know, taking action that merely harasses or maliciously injures another, using means to embarrass, delay, conduct prejudicial to the administrative justice or discriminatory, or just generally bringing the legal profession into disrepute. But it's got to be really bad activity, and it interferes with the legal system, or it brings the legal system in some sort of disrepute. So, you know, these are the kinds of things, you know, does it pose a serious threat to undermining the public's confidence? And what would be a typical example? The lawyer used foul or threatening language towards someone in the presence of others, it doesn't help, or in writing. Usually it's these letter writings that gets most lawyers into trouble in this area. The context involves the practice of law. It can be outside the practice of law. It can be, but usually it's within the practice of law. And it crosses the threshold of unreasonableness. And when I say unreasonable, it's more like outrageousness. So what's the characteristics of the ones that we have prosecuted? It's multiple claims of unprofessional conduct. So we're starting to see that pattern. It isn't just one time. I blew off some steam, and I regret saying it. No, this is a pattern where they have done this to many different, you know, lawyers or even others. Physical harm or threats. Unfortunately, we're seeing more and more, particularly with lawyers that we're prosecuting in our office, where they are engaging in more heated rhetoric, if you will, particularly directed at some of our staff. The use of foul or threatening language documented by letter, transfer, provided, and it diminishes. The lawyer has lost all professional objectivity. In other words, what they're filing is like almost like crazy. It's like, something got dismissed by the court, and then they keep refiling it. And you're like, why are you doing, and and they won't let it go, and they'll just file more lawsuits and more lawsuits. You can tell that they've lost their whole professional objectivity, and there is some sort. We believe there's some underlying impairment, but most of these lawyers are not doing it. And this was a very weird case where a lawyer was licensed for 13 years. He created a fake Facebook account, and he used that account, and for some reason, he was targeting this one woman attorney. He didn't currently have her as an opponent in a case, but they had had cases where they were on opposite sides in domestic relations for many years, and he used that account to suddenly start targeting her in these things, where he created a false review of her legal abilities on Martindale Hubble, Lawyer.com. He registered, this sounds like something from high school, he registered her name to get some sort of obesity action coalition or materials from that organization. Like these fake magazine subscriptions, some people do it. She started receiving emails from that. He registered her online for diet giving. I think he also, this is not on here, I think he also had created some sort of fake account on a dating website, and here she was a married woman, with children, and he's like, saying like, I'm looking for, like I'm a swinger or something. So I kind of went on big international, some sort of, it was just so, that's what I mean. You read this stuff and you're like, what is this? I thought that was odd. He registered her name for auto trader. So she started getting calls from dealerships about that. But he was charged with involving dishonesty, fraud, deceit. So bring, that sort of fraudulent conduct, if you bring all this up. And the board found that this was not a sudden burst of anger. This was, obviously very calculated and tested over a long period of time. So he was trying to say he was under a lot of stress, and from handling family law cases, but they were a little trouble that he was still. So he got 6 months UFO. So 6 months, and then he has to petition to get that in.
Mary, what does UFO mean?
It means until further order of the court. So it means in that case, 6 months from the date of the court, effective date of the court's order. Okay, he served that. And then it continues until that lawyer decides to petition to get reinstated. And the burden is on that lawyer. It's not the 6 months, okay, I'm back. The lawyer has to petition to get back in, and the burden is on the lawyer to get reinstated. And it's the same burden as if he was disbarred. You have to show not just what the seriousness of the conduct was, what have I done to learn from that, to rectify that, and to prevent it so that it cannot keep occurring in the future, that I am at good risk to get back in. Those are very difficult. Reinstatement petitions are not the percentage, we looked at it years ago, but the percentage of actually, the few that actually decide to do that, because it's a lengthy process, and you probably would want to hire a lawyer to do that, that's here before. And those are expensive proceedings. So say you even did it on your own. The chances of getting back your license are probably less than 20%. Less than 20% chance if you actually get it back. So, the thing with incivility, you can't figure out why somebody is what they are. If they have mental health or substance abuse, problem, or they were just dropped on their head wrong, when they were a kid or something, you can't figure out why. They're working out some issue. But you always, it's your own conduct and how you react to that makes the difference, so that you're not part of this, problem, and you are not taking the stress or whatever that negative stuff is into yourself. So don't take it personally. I know that's always difficult, but you say, hey, I got a job to do. That's why I'm here. You know, I'm here. I'm representing this client. I'm going to get to do I'm going to do a good job. I'm going to do it efficiently, and I'm going to get this over. But to the extent that you got somebody that's wild and out of control, or they're just a no-good liar, you know, you agree to continuance, and they bald-faced lie, later, you never agreed to, make a record. You always want to confirm things like that. People like that, it's like, they'll say one thing and remember another thing. Only involve the judge when it's really enough, where the judge's interest is in the game. Hey, why is it slowing this down? Why is this, not, following my order? So, I mean, to the extent that that's something that the judge needs to know about, then you decide. But otherwise, you look like two children fighting. That's what I've experienced. And involve us. If you think it's, something where it's serious, and I know it's always hard because there is in the rules, and some lawyers, and I pointed out to some lawyers, but some lawyers are aware of it. You report another lawyer. This lawyer, he called me a name. But it's ongoing litigation, right? The case isn't over yet. That lawyer, I guarantee you, will probably say, that lawyer is only reporting me because they're trying to gain an advantage in a civil matter. That's their rule. I think they moved it from 1.3 to, I think, 8.4. So they're like, yeah, he or she's only doing that because they're trying to force me. This is like extortion. They're trying to just use this as leverage in order to get what they want in their case. That's neither here nor there unless you are trying to do that. If you tie the two together, do this or else I'll go to the ARDC. You tie the two together. If it's something where this is crazy, I'm just telling the ARDC, this lawyer's kind of out of control. Maybe somebody needs to look at it. They can always say, hey, he's trying to do this. But if you tie the two together, if you make that part of the reason, or the only reason why you bring it to us, then you could be shining the spotlight, not just on that lawyer, but also on you. The HIML duty, I'm not going to tell you other than, it's there. It's a mandatory duty when you have unprivileged knowledge, meaning information that is not given to you by the client or through the client with an expectation of confidentiality. So it's not privileged information that not suspect, suspect like somebody told you in the bathroom, hey, I think Joe is, blah, blah, blah. It's where I have some facts that what caused me to reasonably believe that this lawyer may have committed a crime or a fraud. That's really what that is. And resources, just to conclude, at our ARDC website, you can always look at the rules of professional conduct. Guidance on the rules, we have our ethics inquiry hotline, but not today. Free CLE, so all of our CLE is accredited for professional responsibility credit. And the Lawyers Assistance Program, which you're going to hear about in a minute. And talking it out with lawyers, that is part of an exception to the confidentiality rule. So it's not just, talking to laugh, but it's also if you need, as a lawyer, to reach out to another lawyer to get some sort of, opinion about what you need to do or not do in order to comply with the ethics rule. So with that, thank you very much and enjoy the rest of your day.
Thanks, Mary, for that very informative presentation. Now that Mary has made us even more anxious and depressed than we otherwise are, with all the thoughts about the ARDC, we're going to hear from Linda Brzezinski, who is a volunteer with the Lawyers Assistance Program, which we've already heard just a little bit about. And Linda is a former deputy chief of the criminal division of the DuPage County State's Attorney's Office. Her legal practice now is devoted mostly to teaching and writing, including subjects like criminal law, juvenile law, and code administration. But she's here today as a volunteer for that to talk with us about mental health and substance abuse issues, and I'll have Linda start talking here in a second as soon as I get this going.